Good afternoon. Today's webinar topic is Alternative Dispute Resolution, how small businesses can resolve disputes without litigating. We welcome all of our COSI members on the webinar today and know that there are some non-members here as well. If you're interested in joining COSI, please visit www.cosi.org for membership information after today's presentation. Before we get started, I would like to take a moment or two to go over a few housekeeping items. My name is Pamela, and I will be the web organizer for today. We want to make sure today's presentation is extremely valuable for you. So we ask that you submit all questions by clicking on the question button in the control panel and typing your question. Our speaker today is David Schaefer. David Schaefer is a principal at McCarthy, Lebit, and heads up the firm's Alternative Dispute Resolution practice group. He has been litigating for more than 35 years and is a member of the National Academy of Distinguished Neutrals and a perennial Ohio Top 100 super lawyer. For nearly 20 years, he was an instructor at the National Institute for Trial Advocacy in Chicago. This year, David earned Cleveland, Ohio Lawyer of the Year honors from Best Lawyers in America, which is a peer-rated directory of U.S. attorneys. At this point, I would like to turn the presentation over to David.
Thank you, Pamela. The title, Alternate Dispute Resolution, may make some of you wonder, alternative to what? And we're speaking of alternative to the courthouse, because trials, whether they're in front of a judge or a jury, they are a method of dispute resolution. That method for small businesses or even medium-sized businesses became too time-consuming and too expensive. There's a little bit of information about the law firm. Now, when we talk about alternative dispute resolution, today we're primarily talking about mediation and a little bit about arbitration. Before we get to the world of today, a bit of history is appropriate. Way back when, hundreds of years ago, the elders in their villages used to actually mediate. They didn't call it mediation, but they settled disputes amongst younger folk and amongst factions between the villages. And they did it by developing a dialogue, and one elder or the other served as a neutral, or on occasion, they would bring in an elder from a third village. The point is that the process of mediation has been modernized, but it's not new by any stretch of the imagination. Why do we mediate and to a lesser extent arbitrate? We mediate primarily to save time, stress, and money. And sometimes mediation will permit the parties who are in a dispute to salvage the relationship. In the business world, it's not uncommon for that to happen if a mediation is successful. Now, quickly, a note or two about arbitration. Arbitration is different. It's almost always with lawyers who present evidence. There's direct examination, there's cross-examination, sometimes there's closing argument, briefs get filed, and modern day arbitration is a lot like courtroom litigation, but it's outside the courtroom. There's no judge, there's no jury, there's an arbitrator or a panel of arbitrators who decide the dispute, and it's very difficult to get an arbitration award changed or overturned. I'm not going to say it's unheard of, but it's very, very tough to do. The party that wants to overturn the award has to either show fraud by the arbitrator or that the arbitrator exceeded his or her authority. Now, how do we get a mediation started? Typically, it is with lawyers. It doesn't have to be. But typically, in the business context, the person who deals most with lawyers in small and medium-sized businesses is usually the financial officer, CFO, controller, treasurer. And when the dispute arises, that person usually goes to his or her lawyer. I think that mediation is well enough known that it would be rare for a business person not to at least have read about it. And so typically, at least 2 lawyers show up. Some mediations have 7 or 8 parties, but for purposes of today, we'll assume 1 party. We'll assume 2 parties, a claimant and what's typically called a respondent. And mediation has to make sense. And what I mean primarily by that is the parties to the dispute have to want to resolve it. They don't always get resolved right at the mediation, but the attitude has to be one of trying to go in with a mindset of resolution. Typically, the mediator gets chosen by a discussion first amongst the lawyers, and then typically the lawyers will go to their clients. What do you think about Mary Smith as the mediator? Well, we don't know Mary. What do you think about Mary? And then the lawyer provides input. And sometimes picking the mediator can go back and forth for quite a long time. There's a difference between private mediation, where there's no sponsoring organization, and what's called non-private mediation, where there's a sponsor. For example, the American Arbitration Association will sponsor your mediation. It will set it up for you. It will give you a list of mediators to pick from. The Center for Public Resources, headquartered in New York, will do the same thing. And if you were to Google arbitration sponsors or arbitration tribunals, you'll come up with more than the 2 organizations that I just mentioned. Once a mediator is agreed upon, the next thing to do is, when are we going to have the mediation? Now, most mediators will have a conference call to discuss what I call the logistics. When are we going to have it? Where are we going to have it? Who's going to attend? Is it going to be considered confidential or not? Before COVID, who was going to attend was easy. It was usually an executive and a lawyer. Where it was going to be was also usually easy. It was at a lawyer's office or sometimes at one of the businesses. Now there's multiple models. Some mediations are still done in person, following the state of Ohio guidelines to comply with COVID restrictions. Some are done by what's called a hybrid model, where all the people who are willing to show up in person show up in person, and the other people who are either unwilling or unable, they're either attending by phone or by Zoom. Zoom has advantages and disadvantages. Phone has the obvious advantage of not having to worry about hacking or technology, but without question, the most effective way to do a mediation is in person, following the guidelines. Choosing a mediator, an important topic. And as I said earlier, most of the time, with some input from the clients, the lawyers pick the mediators or mediator. There are multiple theories on how to pick a mediator. So for now, let's have a one-sided discussion. You want to pick a mediator, and the instinctual reaction is, I want it to be somebody I know, I want it to be somebody I trust, and I want it to be somebody who's going to lean my way. Even though a mediator makes no decisions, No substantive decisions are made by a mediator. Arbitrators do that. Mediators do not. The other side thinks the same way you do. So if both sides have those three criteria, and there are more, awful tough to agree on a mediator. So there's at least one other theory that goes like this. Well, if the other side wants Jim Jones for the mediator, they must trust him. So if they trust him, they will listen to him. And we don't care if Jim Jones leans the other side's way, because this process is by consent. No one can force us to an agreement. The culmination of a mediation is a settlement agreement in writing that resolves the dispute, and no one can force anyone to do that. And I personally have been in mediations where I've seen very strong-willed mediators try to impose their will on one side or the other. In general, it doesn't work. In general, what happens is the side that is the target of that tactic gets resentful, and it can retard the progress of the mediation. Sometimes in a private mediation, like in a non-private mediation, there will be lists that are exchanged. Usually 3 or 4 people on each list. They get exchanged, and then names get stricken from the list. So you now have 2 lists, 1 name each on each list. Party number 1, party number 2, each has a list, and then there's a negotiation, and then a mediator is chosen. And while I've spent some time on this process, it usually doesn't take all that long. It's much tougher to choose an arbitrator, because an arbitrator is going to decide the party's fate. And in a significant case, and small businesses and medium-sized businesses do get involved in 6-figure, 7-figure pieces of litigation or disputes. By the way, some mediations precede the litigation. They're referred to as pre-suit mediation. Most mediations occur after the courthouse says the door has been opened, papers have been filed, and a certain amount of work has been done. And I'm going to talk more about that a little bit later. Now, when you and your lawyer are trying to pick a mediator, what should you be looking for? Qualifications comes first. And I know that's obvious and everybody's chuckling. What does this guy think we would do? Pick someone who's not qualified. Well, I want to add a little meat to those bones. If your dispute involves a contract dispute, you want a litigation attorney who's litigated and tried to judges and juries some contract disputes, so that lawyer knows what the law is. Sure, your lawyer's going to submit a written position paper and it's going to have the law in it, but that mediator should know the law going in. Patience. Mediator needs to be patient. The classic mediation, the traditional mediation, starts out with the person or entity who feels it's been injured making a demand for money. Let's just say it's $400,000. It's a breach of contract. The claimant got the goods. The goods were damaged. They weren't usable. They had to be returned. The claimant paid $150,000 for the goods. But by the time the claimant got to the marketplace to get more goods to replace the bad ones, the price had gone up to $250,000. So now we have damages of $400,000. And while the respondent or defendant is likely not to agree with that demand, the respondent or defendant typically responds with an offer. And there's various ways to compute what the first offer is going to be. Many defendants will take 10 or 15% of the demand, so 40,000 or 60,000, and make it their first offer. 60 would be a little high in my experience. 40 would be a little low. Sometimes it could be 30, sometimes 50, but I think you understand what I'm saying. And typically in mediation, it's like a ping pong ball going across the table with good players over the net, back and forth, back and forth. So in response to the $45,000 offer, we get a reduction in the demand from 400 to, let's say, 380. These numbers are a little arbitrary, but there are techniques. Some people use percentage increments. Some people will say, well, they offered 40, we'll go down by 40. That is sometimes referred to as the increment approach. And usually in the beginning of a mediation, you're either using the pure dollar approach, or the increment approach, or the percentage approach. So let's say the offer goes from 40 to 60. That's a 50% increase. So now 380 becomes, in round numbers, 360. Third thing that a good mediator needs: persistence. You don't want your mediator giving up at 11:30 in the morning when a mediation started at 9. I'm going to tell one quick war story from a mediation I did last week. Very contentious case. Everybody was there in person. People traveled in from around the state. And at about 11:15, 11:30, one of the defendants, there were two defendants, one of the defense lawyers said, "We're not making any progress. The plaintiff's unrealistic. I'm recommending to my client that we end this mediation." And I said, "I don't think that's a good idea. I think we can make progress. I'm being patient, so I'm going to ask you to be patient, and we're going to keep going." Now, I can't require parties to keep going. No mediator can. So you try as a mediator, when you run into that kind of lawyer, you try to have a strong presence. You try to act like a leader, and not to get pompous, but almost like a judge, because a judge does have the power to keep people in his chambers or in her courtroom. Fourth attribute of a good mediator: you want a good listener. When I first started doing mediations, I was a good listener, but I never took any notes. And then I started to get more complicated cases, and I saw that I needed to take notes because I couldn't remember what was happening from room to room. But even if you're taking notes, you want a mediator who's a good listener. Now, how do you find this out when you're trying to pick a mediator? Well, you or your lawyer has to do some investigation. Mediators have reputations, just like lawyers, doctors, accountants, insurance agents, CFOs, CEOs. All mediators have reputations. There's a certain amount of information through Google about specific mediators. Most have websites, but that doesn't usually tell you if the person's a good listener. One indicia is if you can find out how long the person's been doing mediation. Because if the person's been doing mediation for a number of years, that means people continue to use her. And if they're continuing to use her, then that generally means she's a good listener. It's an indicator. It's not a slam dunk, but it's an indicator. In my opinion, you want an evaluative mediator. I have to distinguish that from facilitative mediators. Facilitative mediators carry messages from room to room, and they do not offer opinions, and they do not evaluate positions. My own opinion is that that is less effective than a mediator who is evaluative. Part of the reason that the parties qualify a mediator, make sure that he or she knows the area of law, is they want most people want the mediator's opinion. And consider this, the mediator has no dog in the fight. The mediator is neutral, or certainly should be. So when that mediator gives opinions, as long as those opinions are available to both sides, he or she is able to maintain the neutrality. And maintaining the neutrality is very, very important, and segues into the next point. You want a trustworthy mediator. And again, you have to investigate, or to use a more modern word, you have to vet the people who are being suggested as mediators. And if there's even a sliver of non-trustworthiness, you should pick somebody else. A number of years ago, I was a candidate for a mediation, and all the lawyers were from the East Coast, but the mediation was going to be in Cleveland. And these East Coast lawyers were very, very detailed, ask a lot of questions. And since I've been in litigation in Cleveland for a long time, I knew the local lawyers, because the East Coast lawyers all had local lawyers. And I was asked a lot of questions about a relationship I had with one of the law firms, a professional relationship. And one of the lawyers said, "I'm not sure I'm comfortable with that." One of the out-of-state lawyers said that. And I said, "If you're not comfortable with that, you should pick a different mediator." And they did. And that's how I feel. Those are my sincere feelings. You have to trust the mediator. And hopefully you go in with trust and nothing happens during the mediation that hurts that trust. In fact, the trust quotient, if you will, of the mediator should go up during the mediation, not down. When to mediate? This is more complicated than it seems. I mentioned the idea earlier of pre-suit mediation or pre-litigation mediation. These aren't as common as the others that happen during mediation. It takes an enlightened group of lawyers and clients to engage in pre-litigation mediation. And the settlement rate, which has become a common statistic, what percentage of mediations actually settle at the mediation? That's settlement rate. Pre-litigation settlement rate is lower across the country than post-litigation settlement rate. My opinion on that is several reasons. In pre-litigation or pre-dispute mediation, the parties and their lawyers are still pretty energetic. They're still pretty fired up about the dispute, and that can militate against a settlement. Second, the parties haven't yet spent enough time, usually, on the dispute, so they're not tired of it. They're not sick of it. And a third factor is that the parties typically in a pre-dispute mediation have not spent enough money. They have not gotten to the point where the economics, even for a small business or a medium-sized business, they have not gotten to the point where the economics are overwhelming. But some pre-dispute mediations make sense. One of my colleagues calls them dip the toe in the water mediation. It's not a bad description. It gives you a feel for the other side. If you don't know the lawyers on the other side, you get a feel for them. And you can always come back. You can always resume the mediation if it doesn't resolve the dispute, and that does happen. But let's suppose that one side files a complaint in the courthouse and the other side has answered the complaint through its lawyer. That's not a bad place to stop, take a deep breath, and maybe mediate. The issues are relatively clear at that point from the written documents filed in the courthouse. There will also be written mediation statements. And there's been some money spent, but not a lot yet. And I know it's kind of in the eye of the beholder, but usually at this point in a business dispute with a complaint and answer filed, the parties would have spent somewhere between $0 and $5,000. Now, the mediation costs money. We haven't talked about that, and I will talk about that later. And if I forget, somebody asked me a question about that. But these timing point, I call these trigger points. And once you have a complaint and answer, that's not a bad trigger point. Now, in litigation, there's something that nowadays is referred to as paper discovery. It's the exchange of information between the lawyers and the clients about the dispute. And it comes in the form of exchanging documents, exchanging answers to written questions, and exchanging something called requests for admissions, which I'm gonna not spend any time on. This paper discovery has to be drafted, submitted to the client, approved by the client, sent to the other lawyer. The other lawyer and the other client are almost for sure going to object to a good part of the discovery. They're going to submit their own discovery. This is a somewhat time-consuming and expensive process. And even in a small or medium-sized case, this process alone can be somewhere between $10,000 and $30,000. Because when the other side objects, the courts require the lawyers to negotiate the objections. You cannot go to the judge for help until you've tried to negotiate the objections, and it takes time. And in most business disputes, not all of them, but most, the lawyers are charging by the hour, and you can imagine how the hours add up, and you get into typical Northeastern Ohio hourly rates, maybe on the low side, 175, and on the high side for this process, let's say $300 an hour. So waiting until after the papers have been exchanged, but you haven't had depositions yet. This is not a bad idea at all, because some money's been spent, people are starting to get sick of it, and you have a pretty good idea when you see the other side's answers to your discovery and you answer their discovery, then there's not much left that's hidden in a general sense. There are nuances that are hidden. There are facts that are not out yet, but this is a pretty good idea to do a mediation at this third trigger point. Now, the fourth one is after the depositions of the fact witnesses. It's a rare piece of litigation in today's world that doesn't involve witnesses who testify about facts and witnesses who testify about expert opinions. So in a product liability case, for example, where a product malfunctioned and injured a consumer, the plaintiff lawyer representing the consumer will typically need an expert opinion about whether the product was designed defectively or manufactured defectively, or whether there should have been a warning before the product was ever used, a warning, a written warning on the packaging or on the product itself. And the defense, once seeing that the plaintiff has experts, the defense will get experts. And the experts add another layer of cost. But clearly, the most expensive part of a piece of litigation and the biggest driver to mediating instead of litigating is the cost of depositions. You have to pay the lawyers, you have to pay the court reporter, and it adds up very quickly. Your typical deposition in a small to medium-sized case takes 4 to 5 hours. In a bigger case, takes at least 7 hours, and there are rules that limit the length of depositions, but you can ask the court to give you more time. Typically, the rule is 7 hours. So imagine that even in a medium-sized contract dispute where the goods came in and they were defective and they were sent back, you have deposition of the person who ordered the goods, deposition of the person who received the goods on the dock, so to speak, depositions of people in similar positions on the other side, and the writers of the contract. Maybe it's a purchase order, maybe there's an acknowledgement. You can easily have, in a small to medium case, 4 depositions per side of fact witnesses. That's 8 depositions times 5 hours apiece. That's 40 hours just to take the depositions, let alone prepare for them. And we haven't talked about the experts. So after the depositions of the fact witnesses are taken, there should be very little that each side doesn't know about. Every now and then, somebody's able to hold back on a fact, or there's an expression amongst trial attorneys who walk out of a deposition and say to their client, you know, I think we left some questions on the table. And that means that the lawyer asking the questions got so involved that he or she forgot to ask certain questions. And if that happens, maybe there's a fact or two that is not known after the depositions of the fact witnesses, but probably not. And so now we've spent a considerable amount of money, and it's a very good time to mediate. Once you hire your experts, they're required to write reports, and the reports are rarely under 10 pages, and they're usually single-spaced. But even if they're not, then depositions have to be taken of the experts. And this is really expensive because you're paying the expert, paying the court reporter, paying your lawyer. Everybody's getting paid by the hour except the client. So some mediations don't occur until after all the depositions are over. That would be unusual in a small to medium-sized case, but fairly common in a large case, which I'm going to define as a case where the claimant or the plaintiff is looking for over $1 million. Now, if you're on the East Coast someday or the West Coast, you'd have to raise that 1 million probably to 10 million because the cases tend to be for more money in New York City and in Los Angeles, and in the Midwest, let's throw in Chicago. So this is a very good time to mediate. Now, what do I mean by the next trigger point of summary judgment pending? Very, 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 I can't emphasize it enough, common for after all the depositions are done, one side or both files a motion for summary judgment. And summary judgment, in a nutshell, says to the judge, dear judge, there are no real substantial fact disputes here, and we're entitled to win this case as a matter of law. And we shouldn't have to go to a two or 3 week jury trial to do that. We're entitled to win it on the papers. So here's our motion, here's our brief, here's our exhibits, and please grant our motion and throw the other side's case out. It's not uncommon for both sides to file what are called cross motions for summary judgment, but even if it's only one side, the motion gets filed and it has to be opposed. And then the filing party gets to go again, called a reply brief in support of the motion. Well, you can add up the hours. Easily 20 hours will be spent on summary judgment, if not closer to 30 or 35. And if you're keeping track of the hours, after summary judgment, you're well over 100 hours, even in a small case, unless something unusual has happened. So a lot of money has been spent at this point, but the motions have not been ruled on. They're sitting on the judge's docket in Cuyahoga County, our common pleas court, our state court. The average judge has about 500 cases on her docket, about 300 civil cases, 200 criminal cases. The criminal cases get preference. They go faster by law, so-called Speedy Trial Act, which is mandated by the Ohio Constitution and the United States Constitution. So 300 civil cases, there's going to be summary judgment filed in almost all of those. So the judges have one helper. They have a staff attorney, used to be called a law clerk. Staff attorneys are typically either right out of law school or within 2 or 3 years of law school. Every now and then you have a staff attorney that's been at the court for 10 or 12 years, but that's pretty unusual. So now we have these summary judgment motions pending, but they're not ruled on. This is a very, very common point for a mediation. It's a little late in my opinion, but it's very common. And one thing that is even more common is to do the mediation before the summary judgment is ruled on. Why? The uncertainty of the ruling helps the mediation process. When parties and their lawyers think there's risk, they get a little more nervous and they're a little more inclined to settle, sometimes a lot more inclined to settle. When the summary judgment's already been ruled on, the uncertainty is gone, and that can have a bad effect on a mediation. You may be wondering, do the judges know that a mediation is happening? The answer to that is most of the time they do. Some mediations are done through the court system, and the mediator, our court, Common Pleas Court, has mediators on staff. And sometimes it's a court mediator, which, by the way, they don't cost anything like the private mediators. And other times it's a private mediator, but even when it's a private mediator, the judge usually knows, because mediation is built into the case schedule that the judge and the lawyers establish within 90 days of the case being filed. In Common Pleas Court, it is a very rare case that doesn't have a full schedule through trial within 90 days of the case being filed. It's not on the slide, but mediating after summary judgment's been decided, that does happen. It's not all that common. Pretty much the die is cast, the positions get hardened, but that summary judgment ruling is typically, again, in our state court, 2 to 4 months before the trial date. And as cases approach trial, everybody gets more nervous. Even the judge gets a little nervous, because trials are hard work for the judges. They have to listen closely. They have to rule on objections. Unexpected things come up that they have to be ready for. That's also true of the lawyers. So some mediations, some mediators call these last gasp mediations, or they call them desperate time mediations. There's nicknames, as you can tell. At any rate, within 2 or 3 weeks of trial, there's sometimes a desperate attempt to mediate a case. And what often happens, and this comes up a little bit later, is the mediation doesn't work because there's been so much time spent, so much money spent. The positions are so hardened that it's now we're just going to take our chances in the courtroom and the chips will fall where they may. So sometimes these mediations turn into what some people call setting the table. That's setting the table for the final conference before the judge, before the trial starts, because the judge will try to settle the case. All right, what happens when you're in a mediation and an impasse occurs? You just can't make any more progress. Well, I'm going to try and breeze through these. A common technique is something called bracketing. And bracketing is a high-low technique that works like this. I'm going to go back to my example of the $400,000 demand and the $40,000 counteroffer. And now the ball's in the claimant's court or the plaintiff's court. And the plaintiff says, we will go down to 350 if you come up to 100. So that's a bracket, 350 on the high side, 100 on the low side. And the plaintiff is saying, we will negotiate between these two parameters. Most people look at the midpoint. Looking at the midpoint of the bracket is a mistake. That's not what they're for. They're for expressing where the negotiations should be between. What are the parameters? No mediator can stop people from looking at midpoints. I gave up trying to do that a long time ago. But if all you're going to do is go back and forth on what would be midpoints, you don't need the brackets. What is a mediator's number? Some mediators get to the end of the day, which is usually 4:30 or 5 o'clock, and everybody's tired. And the mediator says, look, I'm tired, you're tired. I'm going to write down on a piece of paper what this case needs to settle for. I'm going to slide it across each table, and that's what the case settles for. Some mediators get very heavy-handed about it, and sometimes it works and sometimes it doesn't. Mediator's proposal is something a little different. That's done when the mediation has adjourned, there's been no settlement, but the parties want the mediator to make a proposal. I do them by email, and I give people 24 to 36 hours to get back to me. And the responses to my proposals are confidential. And if each side accepts, we have a deal. I tell everybody we have a deal, and they write up a formal settlement agreement. If one side accepts and the other side rejects my proposal, the rejecting side does not get to know that the other side accepted. And if both reject, that's easy. Type out an email, no deal. And also no deal if one side rejects. Sometimes when one side rejects, a mediator will go back to the side that accepted and will say, look, I want to take a stab at telling them you accepted. I need your consent. Will you do that? Most parties will not do that, but every now and then somebody will do that and it will work. Private numbers. That's where each side at the mediation gives the mediator a confidential number that's close to what it's willing to settle for, but not quite there. And the mediator decides if the two parties are within striking distance. If they're within striking distance, the mediator goes back to each side and says, look, you're within striking distance of each other. We need to keep going. Okay, Mr. Mediator, what do you suggest? Well, you can go back to bracketing, you can go back to single numbers, or on rare occasions, the mediator will ask the parties for permission to disclose the private numbers. So let's go back to the example. The plaintiff's private number was 300. The defendant's private number was 250. That's certainly striking distance. Go to the parties, say, I want to disclose the private numbers. Let's assume they agree. What do you have when that happens? You have a bracket. You have a low side bracket number of 250, a high side of 300, and that case settles 90 to 95% of the time at the mediation. There's something called med arb. It doesn't not used very often in Northeast Ohio, but it's when you turn the mediation into an arbitration and the parties and the lawyers say to the arbitrator, you pick the number. Doesn't happen very often. Usually it's 7 or 8 o'clock at night. People are pretty frustrated and they trust, obviously they trust the mediator. The mediator is allowed to put on his or her arbitrator hat, picks a number, and the parties are stuck with it. They are bound by that number. It is now over. And all that's left to do is write up the agreement, how long to pay the money, when's the money going to be paid, releases, and the usual stuff that goes with settling a lawsuit. I mentioned earlier setting the table, and you'll see the caption here is why mediations fail. The word fail is in quotes because setting the table is not a failure. If a week or two later, the judge settles the case based upon the progress at the mediation, that's not a failure. Every mediation that does not settle at the mediation is not a failure. What about this idea of free discovery? The idea being that you go into a mediation to get a better idea, a better feel for the other side. You do get information in a mediation that some of which you've never heard before. But keep in mind, the so-called free discovery is not free. You're splitting the cost of the mediator. You're probably paying your lawyer. Your time is valuable, so you're spending your time. And in even a medium-sized dispute, you may have the CFO of the business there, or the treasurer, but the CEO or the president is usually available by phone. So now we're spending two people's time. True failure of a mediation, a lack of authority. This is not fun when you're the mediator and one side comes to the mediation. I'm going back to my $400,000, $40,000 example. And one side, usually it's the defense, comes to a mediation with $75,000 of authority. And there's no human being available to increase that authority. So after the $40,000 is offered, the next number that's put up is 50. And then the next number will be something like 57.5. And the spacing gets smaller and smaller until the defendant reaches 75, at which time the plaintiff is at 260. And the defense lawyer says to the mediator, look, I'm out of authority. I can't reach anybody. When that happens, or if that happens to any of you, you will hear your lawyer say, that's bad faith. That's bad faith negotiation. You brought us to this mediation on a ruse. It was deceptive. We're going to move for sanctions. Now, this doesn't happen often, fortunately. But the lack of authority, if it's sincere and truthful, really torpedoes a mediation. It's almost for sure you're not going to get a settlement at the mediation, and you're probably not going to get a settlement shortly thereafter. Seeking victory. This is real frustrating for a mediator. There are parties and their counsel who come to a mediation. They want to win the mediation. They want to show they're tougher. They want to out-negotiate the other side. Doesn't help the process. What about the mediator? Well, when I am the advocate and I'm not the mediator, I'm happy to say I can only think of one instance where I saw a mediator torpedo a settlement. He just didn't understand the case well enough, nor the economics. Actual failure does happen. Lack of authority is one example. Another example is what I call hoop jumping. The parties and their lawyers come to the mediation just because they believe the court will want to see that they jump through that hoop and that they at least tried to settle the case. But they come with no intention to settle the case. They do offer some money or they do make a demand that's semi-reasonable, but those usually you start at 9, those are usually over by noon, and there's nothing a mediator can do about that. Trends, real quick. Mediations are here to stay. They've been around since the early 90s because of some federal legislation. They're not going away. In fact, they're increasing. It is a rare civil case, civil dispute that's not mediated. There used to be opening statements in mediations, like in a jury trial. Those have disappeared because they retard the progress of the mediation and they irritate people on the other side. Most mediations pre-COVID started with an initial joint session, kind of a meet and greet. We don't have those much anymore, although most mediators have facilities large enough for a meet and greet and to have the spacing. But dispensing with the initial joint session does not, in my practice or my experience, impact the ability to settle the case. Those are my remarks. If there's, I see there's some questions, or I think there's some questions.
There are. Do you want me to read it to you, David?
No, I can read them.
You got it? Okay, I just wasn't sure if it popped up for you.
Is it appropriate to ask for references when evaluating if you want to engage? I assume that finishes with a person as a mediator. Yeah, it is appropriate to ask for references. I don't know how many times. I will say this, it hasn't happened to me very much, probably less than 5 times, but for a mediator who's maybe newer to the Northeast Ohio litigation community, that could happen, or out-of-state lawyers will sometimes ask for mediators because they've gotten to me through Google or a website. Does mediation tend to speed up or slow down the litigation process? Great question. When it works, it speeds it up because it leads to a fairly quick ending. If you settle at the mediation, there's still paperwork that needs to be done, and that paperwork shouldn't take more than 30 days. When mediation does not work, it does slow down the process a little bit, because what most parties say to their lawyers is, look, if we're going to mediate, I'm not going to my deposition. I'm not answering these interrogatories. We need to call a halt to this litigation process and go mediate. That's pretty common, so that does slow it down. You have to be careful to still stay in compliance with the court schedule. Most judges will give you more time on the schedule. They'll extend it if they know that the reason you want to extend it is to go to mediation. If the mediation works, it takes the case off the judge's docket. And even getting rid of one case out of 500 is worth something. And keep in mind that there's a lot of mediations going on. So one judge might lose 10 cases in a month. Are there types of cases that tend to be better for mediations than others? Another good question. I'll say this. It's kind of at the extremes, my answer to that. The really simple cases where somebody slips and falls on ice in a parking lot at Walmart or a mall and sprains an ankle, where the medical bills are maybe $3,500, $4,000, the injury isn't going to stay or isn't permanent. Those cases are good to mediate because they're not so complex, and most of the time the injured person would like their money sooner rather than later. The other extreme is the very complicated cases, construction cases. And for those of you who are familiar with Northeast Ohio structures, many years ago, when what is now the Common Pleas Court was finished in the 70s, there were no mediations, and there were an incredible number of construction disputes. Nowadays, those construction disputes get mediated. The owner, the architect, the general contractor, the plumbing sub, the electrical sub, the HVAC sub, the demolition subcontractor. It's common to have 7 or 8 parties in those cases, and they're so complicated, and they're always in state court, almost never in federal court. They're too complicated to litigate. They just are. Sometimes they go to arbitration. So those cases get mediated, and they're a very good candidate for mediation. But in general, I would say that if the lawyers and the clients get along even a little bit, mediation is a good idea to try at one of the trigger points that I mentioned earlier. I don't see any other questions, Allison, or Pam, if there are any.
No, I don't have any other questions either. Did you have anything you wanted to say in closing, or are you good?
No, I guess the only thing I would finish with is one, I've enjoyed the presentation, hope that the folks listening got something out of it, or at least mediation is higher on their radar screen than it used to be. And by the way, real quick, arbitration for the right case with the right arbitrator, where the cost is controlled and it does not become outside the courtroom litigation, is still a good idea. When arbitration was first conceived for commercial cases in the early 1900s, it was much quicker, much more efficient, and much less expensive. But in the mid 90s to late 90s, the cases got bigger. There was a lot more at stake. And so the big cases are almost as expensive as being in the courthouse. They're faster, they're more efficient, and I would say they're more thoughtful. People will disagree with me, but I would say they're more thoughtful. But hopefully, maybe for the right case, arbitration is also something more on your radar screen. And I thank everybody for listening.
All right, thank you, David. Thank you for sharing so much great information and insight with us today. And thanks to all of you for participating in today's webinar. We hope you found this webinar engaging and informative. And if you have thoughts to share, please let us know. For information about more upcoming webinars, please visit cozy.org/events. Thanks, everyone. Have a good afternoon.